The second issue, and probably this is the more meaty one that I've looked at and have dealt with Rick and Bob on, and that's the issue of non-conforming, or I think as you call them in Houston County, registered mines. I think it's the same thing. So when you use that phrase registered, I think what's being referred to is operations that pre-existed the adoption of the ordinance. The second document I've attached to your agenda materials for your reference is the Minnesota statute on the regulation of nonconformities. I wanted to spend a couple minutes making sure we're all on the same page so we understand what a nonconformity is. A terminology, registered mine, nonconformity. Nonconformity is a general term which refers to something that was legal at one time. It complied with whatever ordinances existed or not, but now isn't legal because the county has changed the ordinance or its rules. So it was legal, but it's no longer legal. You can have a non-conforming use, which is a use of property. Say the county zoned a particular district business, and someone had a business there, that was great. But then they changed the zoning designation of that area to residential. So now there's a business in a residential district. That's a non-conforming use because the use of the property doesn't meet the use requirements of the ordinance. You can have, and the second term under non-conformities, the broad term is non-conforming structure, sometimes called substandard structure. So that would be an example where a house was built on a residentially zoned property, say it was built 2 feet from the property line, then the county adopts an ordinance that says you have to be 10 feet from the property line. So that house, and they didn't change the residential designation, so that house still is a conforming use, still residential in a residential district, but it's a non-conforming structure or substandard structure because it doesn't meet the performance standards of the ordinance. So just some background. Hopefully I'm not going to run out of juice here. Did you lose me? Try that. Just got to knock it every now and then. So those are the particular terms that, as we talk about this concept, make sure we have in mind so we're all talking the same language. Also, an important consideration is that I think many people believe that if something is non-conforming, and the most common terms is grandfather, this is grandfathered in, you've heard that term. Really, that's the concept of nonconformity and nonconforming uses and structures under state law. There's a common conception that if that's the case, they can do that property owner can do essentially anything they want, and the county can't apply regulations to them. That's not correct. The county still has the ability to be able to regulate nonconformities, and that's the statute in subdivision 2 there in 394.36 that I've attached to your agenda materials. The county board by ordinance may adopt such regulations not contrary to law as it deems desirable or necessary to classify, regulate, control, reduce the number or extent of, and provide for the gradual elimination of nonconformities, again the broad term, and occupancies, including requiring nonconformities to conform with the official controls of the county or to terminate within a reasonable period of time. So we need to all be on the same page on the front end that the county does have the ability to adopt reasonable regulations as they would pertain to registered mines, whatever the nature may be. And with that background, I'd like you to turn to the industrial ordinance, and I want to walk you through the key features, and this is, it's on page 2. This is probably the most substantive area where I just took some initiative based on having dealt with the county and other counties on issues of non-conforming mines, and put in some provisions for the committee's consideration that would deal with the issue of registered mines. And what I'd like to do is just walk you through those particular provisions. So if you have page 2 in front of you with all the recommended color copies, it should be red and blue. Right? Did you get colored copies?
Yeah,
Did they get colored copies?
Yeah, there's all colored
Okay.
copies.
So the title would be interim permit requirements, and subdivision 1 and subdivision 2 is additional language that I've thrown out for the committee to chew on the issue of what to do with not just registered mines, but I've also lumped in here mines that have had a conditional use permit for some period of time, and what might happen in a situation where there would be what I would call a desire to convert the nature of that operation from what they had been doing historically to something different. And subdivision 1, prior conditional use permits, recognizes the existence of particular permits, but in the last sentence in that, you can see is the operative one that says any expansion or change in the operation shall require a new, and I see I missed an interim one that will have some polishing up to do, as Rick mentioned, shall require a new, if you choose to go interim use permits, a new interim use permit. So expansion or change in the operation. And what we would do is probably tie in and have a definition of expansion that gave staff and enforcement some more guidance on what that did. But in terms of the concept that I wanted you to understand as you would discuss in the future this particular provision, it's designed to recognize that those mines that have conditional use permits may continue to operate as they have operated. But if someone comes in and changes the nature of that operation or expands, they would have to come through the process and obtain a permit to effect those changes.
Excuse me, Jay.
Yeah.
Conditional use permits, it's my understanding, are good for 5 years, I believe. So this would only apply for 5 years if they wanted to change the use to industrial sand mining.
Yeah, those provisions that deal with that 5-year term need to be adjusted as well. And I don't know that that's a topic for discussion here today, but...
So you mean the conditional use permitting ordinance also needs to be adjusted?
Yeah, the provisions that talk about mines and conditional use permits. Again, I'm looking at just this document. There are other things that we would need to do with the ordinance to bring it all together. But these are the big issues we felt we wanted to talk about today.
Well, the reason I raised the question is now we've got grandfathered mines and quasi-grandfathered CUP mines, right? And interim use permits. So the conditional use permit mines are kind of quasi-grandfathered in until they expire. Is that correct?
There is no word that says expire in the old literature.
Yeah, that's some of the verbiage that we have to deal with. But I think there's not a meeting of the minds amongst the people that view that particular provision about how it actually works.
Okay.
We look at a conditional use to see if it's causing an issue, if there's a problem. Every 5 years.
Is that the 13 findings of fact that you use as problems?
15 for conditional use.
But the notion, I believe, of this, as it would tie into those provisions that would be adjusted, is that if someone has a valid conditional use permit, as state law says, that they're allowed to continue, unless there's a concrete condition that establishes a duration limit, which, again, as I mentioned, is of our questionable, perhaps, authority, that generally speaking, that those would continue on, but they would not be allowed to change or expand or convert to another operation. The concept is it's a balance of the interests of the property owner to be able to continue with the operation and the interests of the county to be able to assure that that permit isn't utilized to be able to initiate a use that was never contemplated when the permit was first issued. And quite frankly, and this is true in Houston County, and from my experience, it's true in just about every county in the state. Land use decisions that were made 20 or 30 years ago were not made with the level of documentation and precision that they are today. So there is always some effort in looking at an old permit to try to understand what the original scope was. So this is designed to try to put the county in the best position to be able to deal with that.